Hello, people. We'll be starting with chapter 3. As per the syllabus, the second point is Karya Sanchalan or Ward Samiti. So, that is chapter number 3, Conduct of Business and Ward Committees. So, section number 51, chapter 3, first section is section number 51, that is about the meetings. So, there are two kinds of meeting which are there for conduct of business. First are the ordinary meetings and second are the special meetings. So ordinary meetings are such that they are to be called within 60 days. Within the first 60 days, ordinary meeting has to be called, and there has to be minimum 6 meetings in a calendar year from January to December, that is a calendar year. And in case of a special meeting, they will be called when a resolution for this such meeting is passed by at least one third of the member. Then, and in such cases, the chairperson will fix a date for these meetings within next 7 days. And if the chairperson fails to organize or conduct such meeting within 7 days, then the chief municipal officer, that is CMO, will make this possible within next 10 days, that after the expiry of these 7 days. Next, section number 52 is about the rights. So these are the rights and privileges of the individual members. So individual member can call attention of the municipality toward any urgent topic, like if there was a neglect in execution or a wastage of property or any civic problem in locality. So the members can call attention toward that and can also suggest how the problem could be removed. They can also question the chairperson regarding anything. They can move resolutions there, and they can inspect the material, the documents of the municipality as such without any payment made. Just a notice to CMO they have to do, and after that they can inspect any kind of documents of the municipality. Section number 53 is no confidence. So motion of no confidence against chairperson or vice chairperson. So such motion can be done after the expiry of at least 2 years, after passing of 2 years on the seat. So that much of time has to be there before passing such motion. In case of any such motion is to be moved after by-election, then at least half of the term has to expire before half of the term. It cannot be moved. And in case if such motion is moved and it fails to pass in that particular session, that particular meeting, then it cannot be taken again for at least 2 more years. Section number 53 is about the constitution of ward committees. Now, for how many the ward committees are to be constituted? So, for it can be constituted for one or more ward depending upon the area. Then, who all will be the members of the ward committee? So, the members of the ward committee will be the member representing that particular ward and nominated. So these nomination can be made, a maximum of 5 people can be nominated who are to be have a age above 25 years. Such members can be nominated by a municipality, and these people are to have a special knowledge in municipal administration. This is the basis of their nomination. Now, what could be the disqualification of these members? If these members are disqualified to be members of the municipality, they are disqualified to be the member of ward committee as well. Then, who will be the chairperson of these ward committees? If there is only one ward, then the person who is representing that ward will be the member. If there are more than one ward, then there would be an election, and such election would be conducted after in the very first meeting of the committee, and this will be an yearly tenure. So after every year in the same month, the elections would be conducted. Then their term would be similar to the committee's term, and on their vacating the seat, a successor will become. Only after a successor they will leave the seat. Otherwise, if they vacate in some other cases, or if ceases to member before term, then the committee will conveniently elect any other member for the remainder of the term, not for the full term. Then what are the functions? These are the duties and procedure, or as per decided by the municipality itself. What is the quorum? So quorum is 2 plus 1, that is 2 member plus chairperson has to be present in a committee. Then section number 55 is about the committees. So these committee, there could be different kind of committees in the municipality. These could be the the most important is the executive committee. Executive committees, in Hindi we call them Karyapalika committee. So these are to be have members. So these members include the chairperson of the municipality, the vice chairperson of the municipality, the leader of opposition in the municipality, and there are also some elected member. These elected member would be from council and corporation and board. So from council, there would be from council and corporation, there would be 7 elected member, out of which 2 has to women, and from board there would be 5 elected member. The secretary of these committee would be ex officio CMO, Chief Municipal Officer, is going to be the secretary of such committees, and there could be many other committees constituted by the municipality, such as the finance committee, health and sanitation committee, lighting and public street committee, for building, for slum improvement, for rules and bylaws, and any such other committee can be constituted. And apart from these committee, there could be more committees constituted. These could be the maximum limit is also prescribed, that there would be 8 for the the corporation, and 7 for the council, and 4 for the board. This is the maximum limit as set in the act, but this limit can be increased depending upon the increase in function by the state government. Now, when the committees are to be constituted, the committees are to be constituted within 19 days by the municipality, and if municipality fails to do so, then the state government will constitute the committees. Now, section number 56 is nominations. So, when person other than the members may serve on the committee, these are the nominated members. So how they'll be nomination? They will be based on a resolution. If the half of the member or half of the members of the municipality moves this resolution, then there could be nomination. There has to be limit on this nominated members, that nominated member should be not be more than 1/3 of the member. They will also have the duties and powers and liabilities as per decided by the act, and they also are disqualified as per the act only. So all the powers, liability and disqualification norms are same for the members and the nominated members. Then section number 57 is about the chairman of the committee. So there has who will be the chairman of the committee? So in case there is any ex officio member, like if there is a chairperson or vice chairperson is in the committee, then they are going to be the chairman. If they are not there, then any other member is going to be the chairman, and which is to be decided by the municipality. And if municipality doesn't decide any member to be chairman, then they can among us themselves they can decide it on themselves. In case of absence of this chairman of the committee can nominate among themselves any person as a chairman to lead the meeting. Section number 58 is about the procedures at meeting. What is the procedure to be followed? So in case of any ordinary meeting is there, it has to be conducted after every 2 months. So within 2 months, the ordinary meeting has to be conducted. If the chairperson is absent, in such cases, the chairman or the vice chairman can call such ordinary meetings. For any special meetings, these are to be called within the 2 days of any such proposal, and such request or proposal has to be made by more than 2 members of the of that particular committee. And what is the quorum? The quorum is again, it's half of the member of the committee. So half of the member has to present in any committee so that the functions could be carried out. The next is section number 59, that is subordination. It says that subordination of committee to instruction of municipality and compliance with the requisition of municipality. So it means that municipality committee are always subordinate to the municipality and they have to work under the municipalities. So all the expenditure done on this, any schemes or anything run by the committees, these are to be charged from the municipal fund, and these are to be approved in the budget of the municipality. And if there are any other functions, such as they have to extract from the proceedings or any statement of accounts or any report which are concerning the matter which is directly given to them, such functions are also be to taken up by these committees. Then there could be any the resolutions moved by these committee can be under any revision. They can be revised by the municipality and they can be appealed against. So the municipality has more power, and these revision could be done as per the rules decided by the municipality itself. Next is section 60, functions of ward committee. So what the ward committee has to do? So ward committee has to do the assisting of all the function we have seen. नाली साफ करनी है, सड़क बनानी है, पार्क को क्लीन रखना है, सेवरेज को देखना है, इनफैक्ट स्ट्रे एनिमल्स को देखना है, या फिर जो भी डेवलपमेंट स्कीम्स आ रही हैं उनके लिए आइडेंटिफाई करना है बेनिफिशरीज को, और एनीथिंग, ऑल द फंक्शंस ऑफ म्युनिसिपैलिटी जो उस वार्ड का ध्यान रखेगा, दैट विल बी द जनरल फंक्शंस ऑफ अ वार्ड कमिटी. सो इट विल बी असिस्टिंग द municipality. Section number 61 is powers and duties and functions which are delegated. So municipality can delegate any function to these committees by municipalities. Now the chairperson, if the chairperson of the committee is not there, so the seat of the chairperson is vacant, in such cases, and there is no vice chairperson also, in such cases the municipality can delegate these functions to any such member to act as a chairperson until the new member is elected. We have seen that they are to be elected every year. So until the new member is elected, municipality can consider any person as chairman. One more thing is to be taken care, that if the chairperson was of reserved category, then again the reserved candidate would be on the seats. Section number 62 is about that acts and proceedings of municipality and committee are not vitiated by disqualification of a member. Therefore, it means कि अगर कोई भी एक डिस्क्वालीफाई हो जाता है मेंबर, या कुछ भी डिस्क्वालिफिकेशन होता है, उसकी वजह से पूरी म्युनिसिपैलिटी के जो फंक्शंस हैं उन पे कोई इफेक्ट नहीं होगा. So in case of disqualification of one person, member, chairperson, anyone, it is not going to affect the municipality. If there is a petition to disqualify the chairperson or vice chairperson, ऐसी petition हो तो उससे उन petition से पहले उन्होंने जो भी काम किया है वो काम भी as it is सही रहेगा, वो invalidate नहीं होगा. अगर कोई resolution है about irregularity or anything, then वो भी नहीं होगी, वो भी count नहीं होगी for affecting anyways, except when there is something which is really detrimental. Then meetings, if they are conducted, they will be conducted as such जैसे पहले कर रही थी. Now if there is a vacancy, अगर एक member या दो member नहीं है, it is not going to affect the municipality कि municipality काम ही नहीं कर सकती है. So the acts and proceeding are not going to vitiated by disqualification of members or absence of members. Section number 63 is about the expenditure. So municipal fund ordinary is liable for all cost and expenditure incurred by municipality. There is no personal liability of the chairperson, vice chairperson, or member in case of any. All of them will be directly charged by the from the municipality fund. But in case of any misapplication, then and that too because of direct consequences of some negligible or some neglect, in such cases they will be liable. So in such cases, who will be considered liable would be the chairperson or the vice chairperson or the members or the CMO, or if there is any other officer who is conferred these execution power by the state government. Section number 64 is interest in contract. So official of municipality should not be interested in any contract. So this is basically for the officials. It is not about the members. So the official should not be interested in any contract. They should not be interested directly or indirectly. If they seems to be interested, then they are liable to some disciplinary action against them. Section number 65 is penalty. So for member, officer or employees interested in contract. 64 we have seen about the officers only. Here now we are going to see about the members also and the officers also. So if they are interested in contract, what will be the penalty? Now if a member is interested, then he'll have a fine of up to 5,000 rupees. But there is an exception, as we have discussed in section number 24. There are few kind of ventures which a member can do. In such cases, it won't be considered as a interest in contract. In such cases, member won't be liable, and this will be charged only after a criminal court convicts them. Similarly, for officers and servant, if a criminal court convicts them, they'll be liable to this fine plus any disciplinary action as the government decide. Section number 66 is they'll be considered as public servants. So all the members of the municipality will be deemed to be public servant under Indian Penal Code 1860 Act, and that too section 21. So they'll be all considered as public servants. Now this is all about chapter number 3. It ends the chapter number 3 here. Coming to chapter number 4, that is municipal property. So what all are the properties which belong to municipality? So first of all, section number 6, it talks about the power to acquire and hold. So municipalities can acquire any form of property and can hold any form of property. So it can get these in form of a gift, or it can also purchase that. The property could be movable or immovable, and the property could be within the boundary of the municipality or outside the boundary of the municipality. Section 68 is about vesting of property. So municipality की property किसको सौंपी जाएगी? So all the property in the area of municipality which are not reserved by the state government would belong to the municipality, and municipality will act as the trustee of that particular property. So such property would be like the public lands or walls or gardens या फिर road या फिर जो भी प्रॉपर्टीज होती है म्युनिसिपैलिटी के अराउंड पार्क्स एंड in fact even the stray animals are considered to be a part of all this. Then now if there are any government lands as such within the municipality or outside the municipality, government can give them to municipality by an order, and government can also take back such government lands if they find that there is any mismanagement, or through an inquiry, and if they find that there is any public interest involved in taking that back. Section number 69 is acquisition of property by municipality by agreement, exchange, lease or grant. So municipality can acquire any property. How? Through an agreement, through an exchange, through a lease, or through a grant. So for this, approval has to be given by the state government for that particular property. These can be also donated by any donor, and any trust can also donate or gift such things to municipalities. These trusts are to be the trust under the Charitable and Religious Trust Act of 1920, that is Central Governments Act, and Indian Trust Act of 1882. Any trust established under these two sections can also donate or give property to municipality. Municipality can acquire from them. Section number 69A is surrender. So acceptance of surrender of rights in certain lands and issue of lease deeds can be done by municipality. This is अगर कोई बाहर का इंसान municipality को अपनी कुछ land दे के और के राइट सरेंडर करता है और उसके बदले में लीज अग्रीमेंट लेता है, तो दैट कैन ऑल्सो बी डन. सो दिस इज एप्लीकेबल फॉर नॉन एग्रीकल्चरल लैंड. A person can do so, and a person will surrendering his right, and उसको फिर होल्डर लीज मिल जाएगी. और होल्डर लीज मिलने के बाद जो लीज इश्यू होगी, दैट लीज will be subjected to all the covenants and encumbrance जो भी उस लैंड के साथ पहले से जुड़े हुए थे, वो सब उस पर स्टिल एप्लीकेबल होंगे. सेक्शन नंबर 70 इज अबाउट कंपल्सरी एक्विजिशन ऑफ लैंड. इन केस म्यूनिसिपैलिटी को कोई कंपल्सरली एक्वायर करना है लैंड, तो हाउ दैट कैन बी डन. सो ये स्टेट गवर्नमेंट करेगा. स्टेट गवर्नमेंट एक्वायर करेगा ऑन द रिक्वेस्ट ऑफ म्यूनिसिपैलिटी. सो म्यूनिसिपैलिटी विल मेक अ रिक्वेस्ट एंड स्टेट गवर्नमेंट विल डू सो. तो फिर पेमेंट कौन करेगा, बिकॉज किसको लैंड चाहिए, म्यूनिसिपैलिटी को. सो द पेमेंट विल बी मेड बाय म्यूनिसिपैलिटी. And these lands will be acquired under the Land Acquisition Act of 1894 or any other central act which is applicable. Then section number 71 is about the allotment. So regularization of certain land and their allotment can be done under section 71. So in such cases, अ पर्सन अगर कोई कोई प्रॉपर्टी लेता है, म्यूनिसिपैलिटी से खरीदता है या कुछ होता है, तो दैट कैन बी डन ऑन द बेसिस ऑफ द पेमेंट बाय दैट पर्सन. वो पर्सन पे करेगा. क्या पे करेगा, अर्बन जो भी उसका अर्बन असेसमेंट है या फिर जो भी उसका प्रीमियम है, द पर्सन विल पे दैट थिंग एंड विल बी एबल टू हैव दैट लैंड. एंड ये जो भी चार्जेस इस अलॉटमेंट से जो भी ये पेमेंट आएगा, ये जो चार्जेस होंगे, दीज विल बी ट्रांसफर टू द कंसोलिडेटेड फंड ऑफ स्टेट एंड द म्यूनिसिपल फंड. दोनों में ट्रांसफर होंगे. किस रेशियो में होंगे, दिस विल बी डिसाइडेड बाय द स्टेट गवर्नमेंट. देन सेक्शन नंबर 72 इज अबाउट द कॉन्ट्रैक्ट ऑफ ऑफिसर. सो द ऑफिसर जो भी गवर्नमेंट अपॉइंट करेगी टू एग्जीक्यूट द म्यूनिसिपल वर्क्स, उनको क्या करना है और उनका पेमेंट कैसे होगा. सो दीज ऑफिसर्स विल बी अपॉइंटेड बाय द स्टेट गवर्नमेंट. और इनका कंट्रोल, ओवरऑल कंट्रोल भी किसके अंडर रहेगा, स्टेट गवर्नमेंट में. म्यूनिसिपैलिटी के ऑफिसर्स के अंडर नहीं होंगे ये. सो दीज ऑफिसर, इनको क्या करना होगा, दे विल बी डूइंग द वर्क असाइंड. उस वर्क को असाइन करने के लिए जितना भी सम लगा है, जो भी पैसा लगा है, they will be doing this up to that extent only, and this sum would be charged from the municipality. So section number 72 was the contract of officers appointed by government to execute municipal work and the payment for such work. Section number 73 is about the transfer of property. So provision and related to these property transfer and the contracts are there in section number 73. So municipality can transfer the properties जो उनके पास हैं, they can transfer, they can how. So ये lease भी कर सकती हैं, sale भी कर सकती हैं, या allot भी कर सकती हैं, या कोई regularization भी कर सकती है of the properties. The right is with them. Now in case they are doing any housing or township project, in such cases, they are going to have a minimum of 20% of the area reserved for the EWS, economically weaker section, and LIG, the lower income groups. At least 20% of the houses would be for them, and they would be cross subsidized for this. And this cross subsidization कितना amount में होगा, क्या ratio में होगा, will be decided by the state government. Now, when on finding that ये जो भी allotment हुआ है ये correct है या नहीं है, तो या तो state government will see to that, या फिर any officer authorized by state government will look into this और ये देखेगा if there is any fault, अगर कुछ incorrection है या कुछ है, तो accordingly it will be published in the Gazette. Now, if a person is already in possession in contravention to these, अगर गलती है और वो फिर भी उसके अंदर रह रहा है, तो state government can evict him from that position and ask for the proper refund also. और अगर उसने कोई payment already made कर दिया है, he has made any payment to the chairperson or vice chairperson or member for this particular task, then ये जो भी payment था ये उसको refund हो जाएगा. Section number 74 is about holding. So what kind of holding is there? So there are actually two kind of holding, that is a free holding and a lease holding. So free holding is the one when you have the right in perpetuity. आप inheritance में भी उसको दे सकते हैं, and lease is for the time, जो भी contract का time है. So अगर कोई भी property है section 71 और 73 के अंदर जो हमने देखा है, कोई भी property है उसको अगर हमें कन्वर्जन करना है, इफ़ यू हैव अ प्रॉपर्टी अंडर लीज एंड यू वांट इट इन अ फ्री होल्डिंग, सो उसको कैसे कन्वर्ट करना है? बाय पेइंग अ कन्वर्जन चार्जेस. So this was section number 73A. Then section number 74 is about the inventory and map of immovable property. So all the immovable property of the municipality are to be mapped properly, कि कौन सा एरिया में कहाँ पे ये हमारी प्रॉपर्टी है, उसका प्रॉपर मैप हमने पहले भी देखा था. दिस इज द रिस्पॉन्सिबिलिटी ऑफ द म्युनिसिपैलिटी टू मार्क इट्स टेरिटरी, सिमिलरली टू मैप द property also. So this is maintained by municipality. म्यूनिसिपैलिटी ये इन्वेंट्री और मैप बना के रखेगी, इसको अपडेट करेगी और इसको भेजेगी टू द डायरेक्टर ऑफ लोकल बॉडीज. सिमिलरली एनुअल स्टेटमेंट, अगर कोई भी चेंजेस हुए हैं, एनुअली सीएमओ बनाएगा. The chief municipal officer will make such reports, annual statement, and similarly he'll also send its copy to municipality as well as to the same director of local bodies. Section number 75 is about urban land and properties. So how the records are to be maintained. So maintenance of records of urban lands and properties. So such records are to be prepared or maintained or updated by the municipality only. So municipality ये बनाएगी, सब कुछ करेगी. If it need any help, it can ask other departments or authorities. And in such records, even the private properties are included. So in such, because these are the total land and properties present in the municipalities, so all the private properties within the municipality will also be included. So this completes the chapter number 3 and chapter number 4. We'll be starting the next chapter number 5 tomorrow. That's all for today. Thank you.